Hi, my name is Lise Johnson, and I'm the head of investment law and policy at the Columbia Center on Sustainable Investment. And my session is on the international legal frameworks governing investments in extractive industries, with a focus on international investment treaties, which are treaties that are designed to protect the interest of foreign investors. So I have a number of questions already, and one that I wanted to start with is a relatively timely question on what impacts would the Trans-Pacific Partnership Agreement have, if passed, on the legal structures governing mining and arbitration. I think it's a really good question, and one that is on the forefront of a lot of people's minds right now, is that agreement is currently up for ratification by 12 different countries. The short answer is that it can have a significant number of impacts on the legal structures governing mining and arbitration, and I'll give just some examples of how that is. So a recap of investment treaties and what they do and what the Trans-Pacific Partnership does in the investment chapter is it provides a set of norms that protects the rights and, according to some, even the expectations of foreign investors when they invest in the host country. And it also contains a mechanism of investor-state dispute settlement. So if an investor alleges that the government violated the treaty, then the investor can sue the government directly in investor-state arbitration. So some of the ways that this framework can impact the governance of extractive industries, I think you can see in some recent cases under the NAFTA, which is relatively similar to the content of the TPP. So under the NAFTA, for example, we've had one case against Canada that related to its effort to impose performance requirements on foreign investors in extractive industries, or on investors generally in extractive industries. And what the government of Canada had done was ask investors investing in offshore oil development to invest in education and training and research and development off the coast of Newfoundland, to invest in those activities in Canada as a condition of getting permission to exploit the natural resources. In Canada's eyes, what it wanted to do is ensure that the investment in the extractive industries actually led to long-term growth and sustainable development through investing in developing education and training and R&D, so investing in capacity building domestically as opposed to just extraction of the resources. Under the NAFTA, however, a tribunal found that those requirements on the company to invest in R&D and education and training actually violated the treaty, and ultimately awarded the investor roughly 17 million Canadian dollars as compensation. And there's a second case about that pending now. So I think that's one example of how an investment treaty can sit on top of the domestic regulatory framework and can override a rule that some aspects of that regulatory framework governing extractive industries is not legal and require the government to pay damages. So that's one example. Another example that we see now is with the TransCanada case, and I'm not sure if you've been following that, but recently, after President Obama denied the permit to transmit oil in the pipeline from Canada for export down to the Gulf of Mexico, the TransCanada filed a case in the U.S. courts challenging that decision, but also filed a case in investor-state arbitration challenging the government's decision. In this area, the president has significant discretion to determine how and whether it wants to permit the construction of pipeline. And so courts in the U.S. are relatively hands-off on this issue because of the significant presidential discretion. Investor-state arbitration tribunals, however, aren't bound by those rules, so have the ability to review this decision and potentially award the investor compensation. And the investor in that case is seeking compensation for $15 billion of lost future profits and expenses that have been incurred. So those are a couple examples of how the investment treaties can affect the legal structures governing mining and arbitration. And there are definitely there are many more examples like this, some that relate, for example, to stronger environmental regulations on the mining project, so regulations to prohibit open pit mining. Some have related to a decision by the government not to improve an environmental impact assessment. So with an investment treaty in place, the domestic legal framework is not the only thing that one would have to think about. One would also have to think about the obligations under the investment treaty. And the way the Trans-Pacific Partnership changes that is it's a significant expansion of investment treaties and their coverage and the number of investors that are protected. So that would be a short answer to the first question. Let me see, I'll turn to the next. Another question relates to the asymmetry of investment treaties. So in this question, it says, international investment treaties are recognized to be asymmetric and unfair because they look mainly after investor interest. Does that mean that these treaties were prepared by a lobby of major investors and that new treaties will be fair? Thanks. International investment treaties, what's interesting is they are recognized to be asymmetric. That is because they just do impose obligations on governments with respect to how they treat investors and don't impose any corresponding obligations on investors or on the investor's home state, nor do they provide rights to the host state or rights to other constituents in the host state. So by design, they are asymmetric and looking only at the impacts of government conduct on investors. In terms of whether that is because of how they were produced and prepared, and whether there was a strong lobby of major investors, I think that's an open question, and it depends on the country context. There was a recent book published by Lauga Paulsen, for example, where he looked at why developing countries have signed investment treaties. And for a number of years, throughout the 1990s, early 1990s in particular, there was just a lack of awareness about the strength of the obligations in the investment treaties, which is understandable because if you look at some of the language of the investment treaties, they don't really seem like they impose much on governments, but they've been interpreted in ways that have been very strong and really kind of tied the government's hands in different policy areas. So in some cases, it might be because there was a lack of awareness of the implications of the treaties. In some cases, it might be because there was a strong investor lobby pushing for the treaties. I think that might be more the case now as more and more investors are becoming aware of these instruments and asking their governments to conclude these treaties. Canada, for example, has signed a number of treaties with different countries in Latin America and Africa where there are a lot of extractive industries, so where its mining companies are investing. In terms of whether the new treaties will be fair, we have seen developments in newer treaties to try and protect more of the regulatory space of host governments. There are provisions that do address environmental issues that try and that say that government should encourage their companies to adopt voluntary CSR guidelines. My impression would be that these are improvements, but they don't change the fundamental nature of the treaties that remain the same, where the protections run to foreign investors and not really to anybody else. Some states have proposed different models that would try and change that model. So for example, the Southern African Development Community has come up with a model bilateral investment treaty template, which actually imposes obligations on the investor and states that if the investor doesn't comply with those obligations, the investor won't get protection under the treaty. It also imposes obligation on the investor's home state. So those types of treaties, there are some efforts to shift that model and make them less asymmetric, but that's the exception rather than the rule, even in new agreements. So let's find another question. This question goes to the issue of, I think, the strength of the enforcement of arbitration cases. Have host governments agreed to pay out the international oil companies following arbitration charges? Generally, the answer is yes. And in commercial arbitration, it seems that the rate of payment has traditionally been high, that if there's an adverse award against the government, that governments do pay. In investment arbitration, which is arbitration that happens under the treaty, typically the rate of payment had been high, but you might be seeing some changes to that, where more governments are resisting payment of awards. Now, the thing is that with international investment arbitration, it's very difficult. It can be very difficult for governments to actually resist payment of arbitration awards. And the reason that is because in addition to the bilateral investment treaties or the multilateral investment treaties that governments have signed, governments have also signed 2 treaties on the enforcement of arbitration awards. And those are called the New York Convention, that's referred to as the New York Convention, or the ICSID Convention on Recognition and Enforcement of Arbitration Awards. And once countries sign those treaties, the arbitration awards that are rendered in international arbitration are very easy to enforce in any court around the world. So all that the international oil company would need to do is to take its award to a court wherever the host state had assets and ask the court to seize those assets. The state may still have some defenses that the assets that the company is trying to seize are actually sovereign assets and immune from seizure. But generally, the short answer is that even if host governments resist payment of arbitration awards, it's very difficult for them to actually fight collection if an investor wants to go after their assets. So let me move on to the next question. Here's one that's somewhat outside of the scope of investment treaties, but I just wanted to respond to something on this. So the question is, I would like to know, what do you think about stabilization clauses in the extractive industries contracts in poor countries like in Africa and Cameroon, and where economic growth and development amply depend on natural resources? My answer would be that I think stabilization clauses are problematic in any country, poor or rich. I think the notion of freezing the regulatory framework raises questions for democratic accountability, for generally the power of different stakeholders in order to shape laws to respond to new circumstances, new conditions, new best practices. So I think stabilization clauses raise the same concerns, irrespective of the development level, but I can see that they might raise particular concerns if a legal framework is still really in the process of developing. Now, generally, in many jurisdictions, stabilization clauses are not looked on favorably by courts, where a court, if it looks at a contract entered into by a government and investor that the investor argues contains a stabilization clause, courts in some jurisdictions will not enforce a stabilization clause on the ground that they're either void against public policy or that they improperly fetter or restrain the government's discretion. Now, I think that's an important reason for having contractual review, contractual disputes go through domestic courts, because domestic courts can kind of serve as the guardians of contract law and can police the terms of contract provisions and can actually rule that certain contractual provisions are not valid and enforceable. I think when you have contractual disputes go through international arbitration and you have private arbitrators looking at these provisions, it seems like there is more of a willingness to enforce these according to the terms of the contract, and less of a willingness to rule that such provisions are unenforceable as against public policy or void as against public policy. I've been doing some research on this question, and I haven't found any cases where an arbitration tribunal has actually overruled or said that a stabilization provision is not enforceable under domestic law. So I think that's stabilization provisions are risky and problematic, and I think it's important that they be scrutinized and reviewed by those by courts asked to review and enforce them. And I think that's a key difference between courts and arbitration mechanisms is the extent to which they might scrutinize those types of provisions. Let's look for another question. So this question here is, I would like to know if the international legal frameworks have been or are really efficient in Africa, because it's in those countries where we always have a lot of problems with corruption and other problems linked to mismanagement of natural resources. I think that's a very good question because one rationale given for investment treaties for that aspect of the international legal framework is that the idea behind it is that it should increase the rule of law in the domestic host country. And there's been very little done, though, on whether or not actually investment treaties do have any positive impact on the rule of law. And the one study actually that I found, the empirical study that I found on this, which was done about 10 years ago, found that rather than actually improving the rule of law in the host country, that investment treaties actually had a negative impact on the rule of law in the host country. And one theory of why there is a negative impact, is that if investors have the ability to take their cases outside of the domestic legal framework and take them to international arbitration, then there's less pressure, less political pressure, less pressure from foreign governments, less pressure from foreign investors on the host government to actually improve the domestic legal framework. So in that sense, you create a complementary system or a substitute system that's accessible to some, but you don't have any incentive, or the government has less incentive to address issues like corruption or the independence of courts for everybody else. So that is a theory behind international investment treaties, is that they can be a tool for improving the rule of law, but it seems like evidence as to whether or not they do that is lacking and may actually go the other direction. So here's another question on how can host governments get a better deal with investors in investment treaties and contracts. So I won't deal with the contractual aspect. I'll just focus on how they can get a better deal in the investment treaties. It's definitely an important question. So host countries, it's important to remember that host governments, they don't negotiate the treaties with the investors directly. They actually negotiate them with other countries. And depending on the balance of power between the countries, it might be difficult for a host government to get what it wants out of an investment treaty. It might be difficult if it has its own ideas of what an investment treaty should look like, and it's a capital importing state and it's negotiating with a capital exporting state. It might have a difficult time in trying to get the investment treaty to look like it wants it to look, and to have the types of protections and provisions that it wants it to have. So that's one practical reality. But I think it's important, one, for host governments to identify what they want from an investment treaty and why they want one. A number of governments, one key rationale that host governments have for signing investment treaties is the idea that it will lead to increased investment. And evidence on that is lacking. There's no clear evidence that signing an investment treaty will actually lead to increased investment in the host country. So I think one thing for host governments to do is to recognize that it's not a panacea, that it's not signing an investment treaty won't necessarily bring benefits in terms of investment flows. So signing an investment treaty might not be worth the cost then that it imposes on the government in terms of potential litigation, potential liability, loss of regulatory space. So getting a better deal starts with the question, why would a government want to sign it? Is it in the government's best interest? I think also negotiating a better deal really requires the government to engage in a multi-stakeholder process with more than its domestic investors or more than the ministry in charge of negotiating those treaties. It's important for the government to engage with other ministries at the federal or central level to understand what risks the investment treaty will pose for its domestic policies. So for example, for a government that might be negotiating a treaty that has restrictions on local content requirements, the government really needs to engage with other branches of government at the federal or local or state level that might use performance requirements and understand whether or not restricting those tools in an investment treaty makes sense for it. And if so, what types of carve-outs the government might want. So you need a multi-stakeholder process within the government to understand the implications of the treaty, but you also need a multi-stakeholder process with citizens outside of the government to think about more broadly what types of implications, what types of costs and benefits the investment treaty might present. So getting a better deal really takes a lot of work on behalf of the government. Once it's decided that it might want to sign the treaties, it really needs to do a lot of work investigating domestically what that treaty should look like and have a strong position on what its goals are, what's negotiable, what's not negotiable. So let's find another question. This question, coming from a continent where most of the resource-rich countries do not have a legal regulatory framework on how the local community interests are to be accommodated within the resource sector, what's your advice on what can be done to ensure they benefit? One issue with investment treaties, well, there's two things I'll say about that with respect to investment treaties. One is that generally investment treaties don't deal with the domestic regulation or the contracts between communities and investors or the way that the domestic government wants to allocate benefits to the communities or the rights that it will give communities. It generally just deals with the relationship between the government and the investor. That being said, the restrictions placed in investment treaties, the provisions on government conduct, can impact the government's ability to try and ensure that local communities do benefit from extractive industries, or at least are not harmed by investments in extractive industries. So two examples are, one, looking at how are local community interests to be accommodated. We've seen cases where local communities are really opposed to certain projects flat out, or they're opposed to the way that certain projects are being proposed. So that might be exactly where the project is being proposed for, or the methods that are going to be used in the project. So it might be, for example, open pit versus closed pit mining. When you have an investment treaty, the government's ability to respond to concerns raised by community interest might be restricted, and if the government does respond to protests or challenges from local community interests, it might give rise to investment treaty cases. So that's something that the government really needs to pay attention to also when thinking about whether it wants to sign an investment agreement. Also when thinking about whether to include restrictions on local content requirements, it might want to have the ability to use local content requirements to ensure that the investor prioritize procurement of goods and services from local communities. If you have an investment treaty in place that prevents that, the government might not be able to require or encourage the investor to do that local sourcing. So that's just one way that the investment treaties can intersect with government's abilities to ensure that benefits do flow over into local communities, and the investment treaties intersect with those government efforts and also can limit them. This question about India. So India, the largest democratic country, why has there been tremendous corruption and natural resource allocation to private companies in the last 2 to 4 years? How can this be improved? I mean, I think that question is also somewhat outside of it goes beyond the issues raised by investment treaties. But I think that there's one connection that relates to investment treaties in particular, is that to the extent protection of international investment treaties is denied to companies that have gotten their investments or gotten their concessions of their licenses through corruption, denying the benefits of investment treaties to those investors can send a powerful signal to those investors that they shouldn't engage in corrupt activities, or they should be careful about avoiding any appearance of impropriety in that sense. However, to the extent that international arbitration proceedings allow investors to seek the protection of investment treaties, irrespective of whether they've engaged in corruption, that sends investors the wrong signal. It allows them to engage in corruption through the operation of their investment, and doesn't necessarily penalize them for it, or doesn't penalize them through the investor-state arbitration proceeding. So one thing that investment treaties can do is that they can state that if an investor has engaged in corruption, then it will lose the protection of the investment treaties. Some agreements, such as the recent agreement between Canada and the EU, actually says that if an investor has secured its investments, essentially made the investment through corruption, then the investment will not be protected by the investment treaty. I think that's an important improvement, important recognition. But what it doesn't say is that an investment that there has been corruption throughout the life of the investment, throughout the operation of the investment, those investments don't lose protection of the investment treaty under that Canada-EU agreement. This is where the SADC model, the Southern African Development Community model, does something different, where essentially if the investor has engaged in corruption, even during the operation of the investment, it will lose protection of the investment treaty. So I think that's a better way of sending investors the right signal about both how they get their investment and how they operate their investment. Here, another question is, why, in the name of transparency, did the developed world allow their national oil companies or subsidiary companies to enter into dubious contracts with emerging resource-rich countries? That's a good question. And I think it's even beyond in the name of transparency. I think there are a number of reasons why countries wouldn't want their NOCs or subsidiary companies to enter into such dubious contracts, problems that go beyond this question of transparency. I would say depending on what you mean by dubious, there are some rules in the home countries to police the types of contracts that investors do engage with the host country, but those are minimal, and there are increasing efforts by home countries to require transparency of contracts and payments, but there's still a lot that can be done in that context. And I think here as well, the investment treaties can help improve the situation, but so far they haven't. So for example, investment treaties can impose obligations on home countries to ensure that contracts are transparent, to ensure that their investors are not engaged in corruption. But as I said before, so far, investment treaties, they don't impose such obligations on home countries, and they don't impose such obligations on the investors themselves. So that would be an area where improvements could be made if we really wanted to think about how investment treaties could actually be used to improve governance in this area, as opposed to just protecting investor rights against harmful conduct by host countries. And another question that we have here is, don't I think that the international legal framework is widely responsible for extreme poverty of African countries? Yeah, I mean, I think that's a difficult question, but the international legal framework does have an impact on poverty in different countries. And I think international investment treaties in particular, because of the way that they protect certain property rights over other rights and interests, can actually have a negative impact on things like inequality, and things like growth and development, and the government's ability to be able to harness the potential benefits of investments in extractive industries for long-term and inclusive growth. So it is something that we definitely need to pay attention to, and to make sure that before we expand that international legal framework through negotiation of new treaties regarding protection of these property rights, that we think about the implications of these agreements on issues like poverty and inequality. And right now, that's not really being done. So some have advocated, for example, for human rights impact assessments of investment treaties. But those aren't a prerequisite for signing the agreements or ratifying the agreement. I mean, it's more of an idea than anything that's being implemented. But I think that would be an important step, and something that could be done in order to make sure that the treaties are not exacerbating these challenges that are already present. So here's another question. Could there really exist a fair and equitable treatment from international companies belonging to rich countries and governments from South African countries lacking strong regulation acts on mining sectors? How to break confidentiality in mining contracts? So it seems like there's two questions in there. In terms of the power dynamics between companies and governments, it's interesting because in this question it phrases it as the international companies are the ones that really have the power, as opposed to the governments having the power. And in the field that I mainly focus on, in international investment treaties, the story is typically that governments have the power and investors don't have the power. That investors are really kind of at the mercy of actions taken by the government. So I thought it was interesting the way this question is phrased, because the starting point is a totally different place. I mean, I think there are efforts to increase and to level the bargaining power between companies and between their host governments, but having more of the legal framework really in the domestic law, embedded in the domestic law, is a way to try and avoid the negative impacts of some of those asymmetries in bargaining power. In terms of how to break confidentiality in mining contracts, that to me seems to be more of an issue of domestic law. But then again, it is something that could be addressed through an international legal framework, where you do require transparency of contracts or contractual terms in order as a condition for protection of those under different international legal instruments, so investment treaties or things like political risk insurance. So I think we are running out of questions here. One question is, I don't have past questions in front of me, but it is, according to your answer to the question of Bendris, what should we do? I'm not quite sure what the question of Bendris was, but I imagine it was relating to some of the negative consequences of investment treaties. And so I'll just assume that that was the question and answer that. And I think more attention needs to be paid to these agreements while they're being negotiated and going through the ratification process in order to really evaluate whether the benefits of the agreements outweigh the costs. In many cases, I would say that cost-benefit analysis is not being done, and if it were done, would lead to a conclusion that it's not in the host country or other stakeholders' best interest to conclude such an agreement. In terms of existing treaties that are already in force, governments can also look to see when many of them were concluded in the 1990s and so are up for termination. And I think it's important for governments to assess whether or not they can and should terminate existing investment treaties, particularly if they've been shown not to have led to any increased investment, if they're badly worded and expose the government to wide liability or litigation, as many of the older agreements are. Another thing that can be done is for states to be much more proactive in saying what they think their investment treaties do and do not mean. So for example, saying what they think indirect expropriation means, what they think the standard of fair and equitable treatment means. So there are things that governments can and should be doing with respect to their existing treaties as well in order to try and minimize the extent to which they overly constrain the policy space to regulate in this area. Another question is, how successful is the international legal framework in protecting companies against predatory state behavior? That's a good question, and I think it goes to also this issue of what impacts investment treaties have on the rule of law. I'm not sure that the international legal framework actually is protecting companies against predatory state behavior, but it is definitely providing compensation for predatory state behavior and even non-predatory state behavior. So that's, I think that's the key idea behind the international legal framework of investment protection, is that once a company invests in a country and sinks significant capital in terms of developing a mine or developing another project, that it's then at the mercy of the host state. And so that the international legal framework is crucial for protecting the investor against predatory state behavior. I think we had a meeting at one point with different company representatives on how they manage risk and how they protect themselves against the risk of harm by predatory state behavior. And it was interesting in that the international legal framework, the international investment treaties, were not cited as things that governments or that the companies really cared about in terms of how they protect themselves. Rather, it was other kinds of strategies. So what companies would do, for example, is make sure that they had that they made themselves indispensable to the state, that if the state had the notion that it depended on this company for really efficient extraction of its natural resources, then the government would not want to take action to kick the particular company out. Another thing that companies said that they would do would be, invest in engaging with different stakeholders to make sure that it built up really that protective social license around the investment that would discourage then the government and other constituents from taking action against the company. So it was more of different more actions taken by the government to reduce the risk generally, as opposed to relying on the international legal framework in order to protect itself. Now, the legal framework is there to ensure that the company can get compensation if something does happen, but it doesn't seem like it necessarily will protect a company if the government decides it wants to either seize the asset or take another measure against it. Another question, how long do treaties last for, and how easy is it to renegotiate or end them? In terms of how long treaties last, typically they say they last between 10 and 20 years. There's a provision at the end of the treaty that will say that, and then they either renew automatically, or they usually renew automatically. And different treaties have different provisions on when and at what time a government can try and terminate the treaty. If a government terminates a treaty, there's also usually a provision saying that the protections last for another 10 to 15, even 20 years. So the life of the treaties is considerable. It's very long, and it might be about the length of an extractive project. So that's something to think about when entering into the treaties. But as I said, I think many of them have already entered kind of their first renegotiation or termination phase, and so are up for either termination or joint or unilateral termination. Whether or not how easy it is to renegotiate them, that really depends on the counterparty to the treaty. And from what I've heard, it's not easy to get the other treaty party to renegotiate the treaty, particularly if there's an asymmetry in power. I know some governments who have asked their counterparties for renegotiation, and if it's a capital importing state with a capital exporting state, the capital exporting state is often unwilling to agree to renegotiate certain provisions. Yeah, so that is a challenge. There's a real challenge for renegotiating these once they're in force. So a more realistic option might be to just terminate and start from scratch, or not to conclude new ones. Again, with how easy it is to end them, that's where the survival clause comes into play. It's very easy to send a notice of termination. The only thing is that means that the protections will still stay in force for a window of 10 to 20 years. Now, some countries have accepted that and have said, well, that's fine, we'll just terminate now anyway, and we know that the protections will continue to run, but eventually they will expire. So some countries that have taken action to terminate their treaties include South Africa as a well-known example. Bolivia has taken action to terminate their treaties. Indonesia is going through a process now of relooking at their treaties and terminating their treaties. So they will stay in force for a while, but eventually they will expire. In terms of, I think those are the main things that can be done. You renegotiate them, or you essentially terminate them. Some countries will negotiate a new treaty that will supersede an older treaty that might have left the government unduly exposed to claims. So here's another question. You said that improvement in international investment treaties and obligation of investors can reduce corruption in countries like India. What role do EITI and national resource charters play in compelling government to allocate resources fairly? Yeah, I mean, those are the areas where improvements are being made, I think, in terms of company performance and corporate responsibility. And investment treaties so far haven't picked up those issues, right? They haven't picked up those issues. They haven't embedded them in any of their provisions, and they haven't reinforced them through their mechanisms. So ideally, you would have a system of law where there is policy coherence across these different binding and non-binding, or state and multi-stakeholder initiatives. But right now, that policy coherence isn't reflected in the agreements. So I think that those initiatives are really playing key roles, but it would be time for investment treaties, to the extent they are concluded, to think more about how they can be complements to some of those mechanisms, and not undermine some of the achievements that are happening elsewhere. So here, are there any national laws in any major home countries that regulate the behavior of companies in countries with a lack of strong regulation? There are some examples of national laws, and we have on our website a taxonomy of home country measures in the extractive sector and other areas where the home country does try and regulate the conduct of their companies abroad. And this can happen through a number of ways. One way is through actual regulation, laws and regulations on the companies. And some of these regulations are in securities regulation, which governs issues like disclosure of payments or disclosure of contract terms. Other areas where this happens is through tort laws or laws on negligence. So if a company violates or acts negligently and results in harm to individuals or property in the host country, there can be a possibility of suing the company back in the home country for damages. Those aspects of the law are different in each home country, and I think it's in a state of flux right now. In the Netherlands, there have been some positive developments in terms of holding the home country companies to account for harms created in the host country. In the US, it's very difficult to bring certain claims against companies for harms conducted abroad, but it is an area where, it is an area that is in flux, and new types of claims are being brought, not under the kind of the Federal Tort Claims Act, but under state law equivalents. So there are different types of mechanisms, legal and more common law tort derived, but more could be done in that sense to close governance gaps that currently exist due to international operations. And I think, so we're also running out of questions again. Another question is, what are some of the international regulatory frameworks that exist to ensure that resource extraction, especially of the minerals critical to the functioning of an economy, doesn't result in armed conflict? Unfortunately, there is not much that at least the international investment law framework provides on that. In terms of other international regulatory frameworks, I probably couldn't speak to that. But one issue in terms of conflict and investment treaties that I'll raise briefly. I mean, there have been cases, and there are pending cases where there are conflicts that have given rise to investment disputes. So one, for example, is pending now against Peru, where the government of Peru essentially denied or issued a decree stopping development of a mine after there were widespread protests in Peru relating to mining in the country. So what the government did is essentially issue a decree saying that the investor couldn't continue to mine, and as one reason for doing that was because of the protests relating to mining, and the protests became violent. In response to that decision, the investor sued the government in international arbitration and is seeking damages for the government's action, and is alleging as part of its case that the protests weren't really related to its project, but were related to different mining projects. So I think it's just one example of how the government's efforts to respond to violent conflict or to protests relating to mining developments can result in investment treaty cases. So in that sense, there's a tension between the government's ability to try and avoid conflict and also the investor's desire to try and push a project ahead. So that case is pending now, and we probably won't see any resolution of it for at least a couple of years. Another question. Arbitration, ISDS, restrict governance reform efforts in this area of SDGs and countries' right to terminate, aside from countries' right to terminate or seek to modify binding international investment laws, are there concerted efforts in the international arena to mitigate the effects of ISDS on development? I think that with the SDGs, I think that that provides an important focal point and a frame, a lens through which to view investment treaties and to assess whether investment treaties and ISDS are actually consistent with the SDGs. So at this point, I would say there are not concerted efforts in the international arena to mitigate the effects of ISDS on development, but there's a trend toward development of those efforts. I mean, you're seeing more opposition to that system of investor protection in ISDS arise in Europe, and I think that can spill over into other countries as well. I mean, there's been a lot of question about the effect of ISDS on rule of law and on domestic court systems in treaties between developed countries. So in the agreement between the US and the EU. And a lot of questions have been raised about whether or not you want or need those agreements in agreements between, in treaties between developed countries. But I think one question that we can't forget about is whether do you want them between developed and developing countries or developing countries, or whether you want them really at all. So hopefully some of the concerns that have been raised in the EU in particular do spill over more broadly into more of a concerted effort in the international arena to think about ISDS in connections with development, in connections with the Sustainable Development Goals. I mean, the Sustainable Development Goals, they recognize the need for the policy space and the need for international rules on trade and investment to respect policy space. And that, I think, is an important recognition and provides a good opportunity for input and an assessment on whether or not the treaties actually comply with the objectives or leave room for governments to try and pursue the objectives reflected in the SDGs. So hopefully we see more concerted efforts. The Special Rapporteur on Indigenous Peoples, there's been more voices recently within the UN system that haven't traditionally focused on investment treaties that have been paying attention to these agreements. And I think that's also an important development for kind of spreading efforts to try and reform this area. Another question, Elise, is it not possible to have parties involved, government representatives and investors in a roundtable to amend the treaties? So in terms of amending the treaties and what one would want to do, the amendment itself would have to happen between governments. So you would have the two government parties come together to decide whether or not they could agree on how to amend the treaty. But in terms of bringing other parties to the table, that does and shouldn't happen. And I would say more than just investors. So you see in countries different procedures that have been adopted in order to solicit the views of stakeholders and to take them into account in negotiating treaties, renegotiating treaties, or coming up with their own models. In the US, there's a process where we have a multi-stakeholder body. And we also, the government that's responsible, the government branch that's responsible for negotiating the investment treaties also consults within the government with other agencies. So it's the US Department, the US Trade Representative's Office will consult also with the Department of Environmental Protection, consult with officials from the state and local governments. So there's an effort to try and solicit those views on what an investment treaty should look like. Ultimately, it's not those bodies that have the final say in what the treaty looks like, but there is a consultation process. The EU recently adopted its own consultation process where it solicited views from the public broadly through a kind of an online consultation mechanism, and received, I think it was hundreds of thousands of comments on investment treaties and ISDS. the government of Ecuador, when it was reviewing its policy, set up a commission to review investment treaties and an ISDS. So there are different ways that stakeholders can be brought in to assess existing and potential future treaties, and assess potential amendments. And different countries have done it in using different methods. South Africa also conducted a study and analysis of its investment treaties, and which resulted in a conclusion and to walk away from those treaties, or to terminate treaties that are up for termination. So yes, I definitely agree that it is possible to have other parties involved in formulating next steps and formulating potential amendments. But when it comes to whether an amendment actually is approved, that has to be agreed between the governments as opposed to between investors and the government. Here's a question about, it's a practical question, and this is a great question. But suppose a country would like to change the mining regulations and change the contract with international companies. What kind of circumstances should be prepared the country so that the company will sue the country in arbitration? So it seems to me that the question is getting at if a country wants to change its mining laws and change its contract, what should it do in order to try and avoid arbitration from the company? One initial thing that I would say is, I think it's important for countries to be able to change their mining laws and their regulations, to be able to keep them current, keep them consistent with best practices. And it's something that happens all the time. You have an updating of environmental laws once you become more aware of the different impacts that mining operations have. You have frequent changes in fiscal regimes. There's a study that some of my colleagues did a couple of years ago looking at how frequently fiscal regimes in the extractive industry sector change in developed countries. I mean, it's something, change is more of the norm than stability in terms of a taxation regime. So the ability to change laws and regulations, I would say that the government is generally able to do that, notwithstanding the fact that a project is already in existence. That being said, if the change is significant or seems like it will have a significant impact on an investor's bottom line, you may have a risk that the investor will bring a claim. And in those cases, there's really not much a host country can do. I mean, I would say refrain from, when thinking about passing the law, refrain from making statements about the desire to harm a foreign investor, making sure that the legal change is grounded in an important, legitimate public policy will help protect against successful claims. And ideally, the company will have a long-term interest in staying in the country and won't want to threaten litigation in order to prevent, or proceed with litigation in order to prevent the country from changing its laws. Things are different the more you have in a contract. The more that's in an investor state contract, the more that's embedded in the contract, the more it will be difficult for a government to try and change laws impacting that contract, or to try and change the contract itself. Tribunals really have focused on enforcing the sanctity of contract and investors' rights under contracts. So it is more difficult for governments to go ahead and try and terminate contracts, or to try and change legal regimes affecting contractual performance, or try and change the contracts and not be at least threatened with claims under investment treaties. So as a general strategy, the more you put in law, as opposed to the more you put in contract, is useful for also protection under investment treaties and trying to avoid claims there. But whether or not you wind up in arbitration, or whether or not an investor threatens, I think that also has to do with the nature of the investor and its kind of commitment to the host country as well. So I think, well, now there's a number of more questions, but I think we're running out of time. But yeah, I don't think there's any that I can address within the next minute. But thank you very much for your time. Hopefully the answers were somewhat helpful and useful. And we can also continue the discussion in the online forum. All right, thank you. Bye.